Thank you, Andramaki. It's an honor to be part of this celebration, this huge birthday party significant to Canada. Bonjour tout le monde.
Good evening, everyone.
The organizers on their perspicacity in the choice of the topic for this morning's session, the role of an apex court in a constitutional democracy. I'm certain no one could have known that what could have been a very esoteric topic would end up being a current affairs panel. And you could not have chosen better panelists. Dr. Stephen Toope has written A Rule of Law for Our New Age of Anxiety. It was just published last year. It contains many references to the 45th presidency of the United States. After today, I'm sure it will be a bestseller. I have to tell you, it's available on Indigo. Our next presenter is the inimitable, the Honourable Albie Sachs. His book, The Strange Alchemy of Life and Law, was published in 2010. But every thought and idea resonates today as if it were just written. It's available through Oxford University Press. You will also see in the online version of the biography of Justice Sachs that he has a new project, and you can click on a link that will take you to an amazing tool that draws you into the principles that have guided his life. It's called the Albie Conspectus of the Life, Love, Law, and Laughter of Albie Sachs. With that, I will let their words be their best introduction. Stephen will begin with an overview of his thinking in relation to the rule of law. He'll be followed by Albie, and then I'm going to ask them some questions. They don't necessarily know the questions I'm going to be asking them, and there will be an exchange between them, followed by questions and comments from you. And we're going to preserve about 10 minutes at the end, 5 minutes for each of them to offer a summary and to tell something of significance to them in relation to today's topic. So we will begin with Stephen, please.
Merci beaucoup, Georgina.
Thank you very much. First off, I'd like to thank you. I'd like to thank the justices for having me, invited me this morning. It's fantastic to be here.
Nerve-wracking, I have to say. As you suggested, I think when Albie and I were asked to be on this panel, neither one of us could have imagined that the topic would be so timely and the need for courage in defending the independence of the judiciary globally so urgent. Of course, for years now, the judiciary has been attacked or muzzled in countries as diverse as China, Russia, Turkey, Hungary, Poland, and I'll say even in the UK. When I was there, one tabloid in that country famously labeled the Supreme Court enemies of the people after a ruling in relation to the procedural shambles of Brexit. And sadly, there was not much government defense at that point. So this is not something that is entirely new, of course, and indeed it is a global phenomenon. But we face something really unique and potentially devastating today. In the oldest continuous constitutional democracy in human history, a president forces his chief justice to issue a measured public statement of rebuke. And I quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose." End quote. The president's response: frontal attack. "We have very bad judges, and these are judges that shouldn't be allowed. I think at a certain point you have to start looking at what you do when you have a rogue judge," end quote. Meanwhile, members of the majority in the House of Representatives have issued a series of articles of impeachment against any judge who has ruled against the president in one of the many legal processes, I think there are 150 now, in which the president has been engaged. And the vice president and the president's Svengali, Mr. Musk, both tweet regularly with brutal attacks on individual judges and the judiciary collectively. Well, as you know, in a constitutional democracy, apex courts have a number of important functions: to issue final decisions that can be understood and relied upon by the parties, to uphold constitutional rules and norms, to protect the liberties of individuals and groups, especially minorities, within the democratic polity, to police the separation of powers, to contribute with a strong voice to the legal and democratic dialogue within and across borders, and to guard the independence of judges and judicial institutions. Well, in the United States today, as in many autocracies around the world, the executive seeks with great determination to undermine many of those roles, especially the policing of the separation of powers and the duty to uphold fundamental constitutional rights. But I want to focus in these opening remarks on a role that may underlie all of the others: to uphold and strengthen the rule of law. The PEI judicial impartiality reference from 1997 was interesting in this regard. The Supreme Court of Canada noted that one of the social goals served by judicial independence is the maintenance of the rule of law, a goal of judicial independence to maintain the rule of law. Well, why might that function, judicial support for the rule of law, buttress all the others? Because I believe that the rule of law is nothing less than one of the greatest human constructions of the modern era. Now, I'm quoting here from someone you might be surprised by if you studied history. It's the English Marxist historian E.P. Thompson, who was no friend of elites, but he believed, and I do too, that the rule of law is a remarkable creation built over generations through practices of lawyers, judges, political actors, civil society, journalists, and citizens. It's now under threat, I think, as never before in the post-Second World War era. In the Western world, and especially in the Anglo-American world, we've inherited, I believe, two directly conflicting attitudes towards the rule of law. One is the dismissiveness that I've already noted. Law is nothing more than an instrument of power to be overridden when necessary or deployed to accomplish ends that have nothing to do with the law itself. I think that attitude is an artifact of both the left and the right, interestingly enough. The other attitude is, in my view, almost equally unfortunate. It's triumphalist. Law is the defining feature of society, overriding all other contributors to social integration and cohesion. So in that sense, I think that some of the current threat to the rule of law is self-generated. Across the late 19th and 20th centuries, generations of lawyers, I believe, overclaimed our role in society building. Legalism ran rampant across wide swaths of social endeavor. Ironically, or perhaps causally, the strongest example of this was in the United States of America, where lawyers came to dominate many political institutions and litigation became a dominant form of dispute resolution. Law even became a preeminent form of dispute creation, not so much a shield against abuses as a sword to attack perceived enemies. But I want to argue that the rule of law is not the same thing as legalism. It is, properly conceived, not triumphalist domination, nor is it a meaningless concept subservient to raw power. If we're to deploy the rule of law effectively as a counterweight to populist nativism and authoritarianism, the rule of law is, I believe, best articulated modestly, not as an imperial project of the legal profession or of judges, but as one key contribution to the various social processes that together build up social stability and resilience, while also allowing for needed societal change. Now, in practical terms, that means that the rule of law should be viewed as primarily procedural in content, I believe. And I think that that was the Diceian view, in fact. It encompasses what Jutta Brunei and I have called the criteria of legality, the criteria that allow social norms to be transformed into law, requiring, for example, that law is forward-guiding, generally not applied retroactively, that law is made openly and not through secret diktat, and that the law is understandable by the people to whom it is directed. Importantly, the rule of law requires that law is applied to all people in a society in an equal manner, through institutions like courts and administrative systems that are themselves subject to due process constraints. The Supreme Court of Canada decided Roncarelli and Duplessis some 66 years ago. Though it did not use the term rule of law, the majority held that a powerful premier was accountable for an abuse of office. Now, as was often the case at the time, the real rhetoric in the decision was in a separate opinion, of Justice Rand, where he really did articulate a more forceful, clear understanding of the rule of law. But the majority really did focus on the key issue. And that was reaffirmed in the Quebec secession reference in 1998. Quotes, "There is, in short, one law for all." Or, in the words of the South African Constitutional Court in Fedsure Life Assurance, "The legislature and executive in every sphere are constrained by the principle that they may exercise no power and perform no function beyond that conferred upon them by law." Now, this element of the rule of law is challenged today by authoritarians worldwide, from Orban in Hungary to Museveni in Uganda, from Netanyahu in Israel to Sisi in Egypt, from Erdogan in Turkey to Modi in India, who argue that the executive power must be largely unconstrained, typically in the name of effectiveness or the higher interests of the state. And increasingly, that argument is being made by the legal enablers of the current US president, who suggests that ideas in American law, like the unitary executive or national security imperatives, allow the president to exercise broad, essentially unchecked powers. For a preeminent example of that argument, it's worth looking at a book by John Yoo called Defender-in-Chief, Donald Trump's Fight for Presidential Power. A very distinguished legal scholar, by the way. Of course, the recent decision of the US Supreme Court in Trump versus the United States, holding that presidents have immunity from criminal prosecution for acts conducted under their core constitutional authority as president, and presumptive immunity for all official acts, helped to buttress a view that presidents are not subject to the same law as other people. And so today, the central principle of US constitutionalism, grounded in the rule of law, that governmental powers are not omnipotent, is under threat. The US Department of Justice now argues that the inherent power of the president can be exercised to summarily deport any member of a designated group, in this case purported members of a Venezuelan gang, and to imprison them in a compliant foreign country with which they have no connection. As a commentator in the New York Times noted, this argument is effectively a declaration of a state of exception, where the rule of law no longer applies. And the state of exception is exactly the argument put forward by the Nazi-supporting legal theorist Carl Schmitt when he argued for the total power needed to make Germany great again. Now, for years, I have resisted the Nazi analogy, to to our contemporary circumstances because it seemed lazy and overwrought. But I think we can no longer avoid it, not when President Trump declares, and I quote, "He who saves his country does not violate any laws." If we're to reject both a triumphalist understanding of law as a simply command or of law as merely the handmaiden of political and economic power, we need a clear articulation of the rule of law, crucially important today. Because we can only expect people in a society to show fidelity to law if they can also expect those in public life and powerful people in the private sector to do the same. Law is, in that sense, generally self-enforcing, but only when people view it as legitimate. And so my version of the rule of law must include a compelling view on how law is legitimated in healthy societies. And here I rely on the work of David Deisenhouse, who argues that legal systems are held together by what he calls intrinsic qualities that give law its authority, and without which there is neither law nor authority. And that's essentially the argument that I made earlier about the importance of what I call criteria of legality. Well, all of this, I think, means that the need to bolster legitimacy in the rule of law is crucially important in our era, when radical diversity and deep pluralism are increasingly recognized as social realities globally, if not always as social goods. In that context, as I began, I think that the rule of law is best described with modesty. It does not represent a universal understanding of the good life. It does not encompass all human rights and freedoms, which I think are argued for separately, often through political processes. Nor does it necessarily require particular forms of social decision-making. It does, however, help protect people against chaos and anarchy, as our Supreme Court opined in the Manitoba Language Rights Reference. That is no small thing in our seemingly ever more chaotic world. Thanks.
Thank you very much. Over to you, Albie.
I'm going to start very ungraciously with 2 complaints. The first thing is it took me more than a year to get over my withdrawal symptoms after I left the court. And now I'm sitting up here, and they're all coming back to me. The second is you called me Honourable, and I'd explain why it's disconcerting. The transition from this beautiful, grand space, this splendid building, to where the little manger in which the Constitutional Court of South Africa was born couldn't be greater. Low ceiling, 2 offices, the wall had been knocked down, but we couldn't delay constitutional justice because we didn't have a building. So we had temporary accommodation. And all at the same level, so nobody sitting up looking down. Very excited. Nelson Mandela is speaking. 11 judges plus 1 acting judge when Richard Goldstone went to The Hague. Sidney Kentridge was the acting judge. Can you imagine Sidney? Acting judge. And Mandela begins his presentation. The last time I was in court was to find out if I was going to be sentenced to death. Today, I inaugurate South Africa's first constitutional court on which our democracy depends. We, 12 judges, were thrilled that Mandela himself was projecting in his very first statement the significance of the court. I'd been in the resistance with him. Others had known, called for his release. It was admirable that the president now should be starting with that statement. And how did we show our gratitude for this person the world loved, that we loved? 6 months later, we struck down 2 proclamations by President Mandela. That's what judges do. And they were good proclamations. Parliament had asked him, I'm going to not put it in legal language now, Mr. President, we've had our general elections to create a parliament, but we need elections to create the first non-racial local government in South Africa. And we don't have the time. So we are asking you to issue proclamations to create the conditions, to get the money, to get the secrecy of the vote, to get the organization, the counting, everything. He said, fine. And he issued the proclamations. First time to have local government where everybody is equal in the voting. And so it's a manifestly good law. And we struck it down. The criticism came from somebody from the opposition party disagreeing with certain aspects of the proclamations. We went much further. And basically what we said by a very large majority is Parliament cannot ask the President to pass laws. Parliament must pass the laws itself. Parliament can pass a law and ask the President to dot the I's and cross the T's. But basic legislative authority, in terms of the statement you quoted, belongs to Parliament. And the issue is a profound one. When the Reichstag gave Hitler power, that was the end of democracy. So it's not just a nice thing to do, formal classification, it's foundational. We were very concerned now, how is Nelson Mandela going to respond? We switched on TV. I don't know if you switch on TV to see how the Parliament or others are going to respond to your judgment, but in that case. And he said, I acted on legal advice, that I had the power. I now accept that advice was wrong. And I, as President, must be the first to accept the decision of the Constitutional Court interpreting our Constitution. Now, for me, that day was as important in South Africa as that magnificent day when 20 million people voted as equals for the first time. We got our independence, equivalent independence, not through a formal decolonization and new state. It was the one country, South Africa, but only whites had the vote, only whites had power. Through extending the vote to everybody, it wasn't just a flag coming down and a new flag going up and an anthem playing. 20 million people took part in that constitutive action of creating a new country. But that was political democracy. Now it was constitutional democracy, and the two coming together. You might say it's a lovely statement to throw out on which our democracy depends. Our democracy did depend. One, in terms of the terrible public health pandemic, HIV/AIDS. It was taking away any shine from the achievement of democracy, the miracle of South Africa. Our people were dying in huge numbers, and it seemed to be like a calamity. Antiretrovirals were now becoming available. Our president at that time, President Thabo Mbeki, people called him a denialist. He denied that the HIV existed, it hadn't been isolated, it hadn't been shown, and our people were dying. A very significant organization created Treatment Action Campaign on the ground. It's probably the greatest civil society-inspired piece of litigation in the world, because it literally saved hundreds of thousands of lives. It was the people on the ground saying, we want access to antiretrovirals. A very intelligent campaign then was furthered by people, some living with HIV, others not. And they focused on woman living with HIV, about to give birth, demanding right of access to nevirapine, which cut the transmission by about 50%. The government was limiting supply to 2 sites in each of the 9 provinces. If you had the money, you could buy it. It was safe. The doctors recommended it, but because of this denialism, it was being held back. Our constitution includes social and economic rights. The right of access to health care is a constitutional right. The state shall take reasonable legislative and other measures progressively to realize the right within its available resources. Our little court was packed. The tension was so great. We had people sitting in the court wearing T-shirts saying HIV positive, black, white, brown, just like the nation was there. And we read out the decision and of the Chaskelson. We don't want to punch anybody on the nose. We're not looking for a fight. It's one of our least exciting judgments in terms of the writing and presentation, but the content impact was enormous. And he said that it's unreasonable to restrict. The doctors prescribe it, the women want it, the rights of the children to be born are involved, the rights of the women as women are involved, and total silence. We go out of the court, and cheering starts. And I start crying. And I'm crying not just because of the impact of HIV in our country. I'm crying because as a judge, we're doing something we never even thought of when the Constitution was being written. We never even thought of. I fast forward a couple of years. I'm off the bench. I'm rushing to catch my plane. I'm always rushing to catch a plane. And a big, burly black African man stops me. He says, "Thank you, thank you, thank you." And I say, "It wasn't me, it wasn't me. I've been off the court for 10 years. He said, "Thank you." It was when the court had ordered our President Jacob Zuma to pay back the money of overspending on private security modifications to his personal home, a swimming pool and a few other things like that. And it was a time of state capture, and it looked as though Parliament was failing, the executive was failing, and it was the Constitutional Court now that ordered him to pay back the money, upholding a recommendation made by an institution created by our Constitution, the Public Protector. It saved us. Down the line, the state capture now is being investigated as a result of the report by the Public Protector, and former President Jacob Zuma is invited to attend the inquiry. He doesn't attend. He is invited again to attend, doesn't attend, and the inquiry, that's Deputy Chief Justice, goes to the Constitutional Court and asks the Constitutional Court to issue a subpoena. And he attends, and then he walks out. And it's a crisis in the country now. And the court then says he's defying the order of the court. This is contempt of court. It's blatant contempt of court. And Sisi Kampepe, the Deputy Chief Justice at that stage, issues a 15-month prison sentence, and he goes to jail. And his supporters rise up, and they start attacking shopping malls, and a whole range of mayhem comes, people die. It's kind of critical. But the court held firm. It was the one institution in times of terrible crisis in our country that was holding firm. It was holding firm because it had the Constitution behind it. And the Constitution, that in that sense, had immense significance for our people because it represented everything we've been fighting for all those years. And just let me throw in a thank you to Canada. Gave us so much support of all what was called the White Commonwealth. Canada was the one that stood out, supporting us completely in sanctions, in isolation, and then afterwards also in terms of practical support in many, many other ways. I've been asked not to say nice things about the Canadian Supreme Court because this is not meant to be a self-congratulation session. So I'm going to save it up for later on. But I would like to say, though, that for me it was that withdrawal symptoms that I had were not based on some kind of sentimental softness in my part. We played a huge role. For me, it was part and parcel of that struggle that threw so many of us into jail, that so many of the people I knew never saw democracy. It was part and parcel of it, but not in... Fighting is always ugly. Even a liberation war is ugly. War is ugly. But now it's a way of fighting for those basic fundamental rights, doing things properly, holding Parliament to account, holding the presidency to account, giving space to civil society, giving space, giving voice to everybody, insisting on participatory democracy and not just formal democracy, a whole range of things like that. It was a continuation for me, and that's why I felt so uncomfortable. Now, why was I so ungracious to say, please don't call me honourable? It doesn't mean dishonourable. When we were created, it was a huge act of decolonization, democracy, votes for everybody. But we didn't use the word decolonization, but we wanted to, let me say it, decolonize the law. So we said, please, council, don't call us my lord, my lady anymore, just justice. We decided not to have hierarchies in our court. We rotate the seating. We decided not to have the newest judge start first and go on. I heard from somebody just yesterday how terrifying it is if you are the newest judge. And we decided also to drop the title honourable. And it's funny, you get used to not being honourable. You get used to living in life as you are without the need of a title to distinguish you in any way. So imposing the title is actually not a gift. It's a reminder of the past. But I would like to end by saying thank you to the Chief Justice. You came all the way to Cape Town to invite me personally. The Chief Justice happened to be in Cape Town. We had a very, very wonderful discussion with him and with his wife. I accepted like a shot. Canada has been good to South Africa. Canada has been good to our court, and Canada has been good to me. Thank you.
Albie, there are so many parts of your book that I would like to talk to you about. In this first set of questions, I've picked out 3 consistent with talking about the role of a judge. So it's so clear you lived through 2 distinct systems of justice, the one in the apartheid period and then the new one, the one that flourished, the one that you played a role in developing. During the apartheid period, you saw judges, and this is how you described them, administering unjust laws in an unjust manner. And then apartheid ends, you become a judge, and now you are reflecting on the role of the judge. And fast forward to now, where all of us are thinking about the role of the judge. Could those judges have done something different? And could the judges in the apartheid period have done something different? That's question 1.
Yeah.
The second question is, and I love this phrase, in your book you say, if we as judges are not here to say in our decisions something profound about our country, if we as judges don't say something profound about our country and what it stands for when it's being tested, we are not fulfilling our vocation as judges. And the third one, you observe, a constitutional court does not express power, but it restrains power. Comments from you?
Big example.
I raged against the law when I was thrown into solitary confinement under the law. It had a long title, General Laws Amendment Act, Section so and so, so and so. Any police officer of a certain rank who suspected that I had information about subversion could have me locked up in solitary confinement, no due process, under the law. So rule of law became very ambiguous in South Africa. It was rule by law. The mere fact that I think there's three basic criteria of predictability. We predicted it was awful. Understandability, yes, it was hell for us. And the first one, not retroactive. So it made us very disdainful about law. And I came up, though, with the phrase, we must be always skeptical of law's pretensions, but never cynical about law's possibilities. And that helped me, particularly now as I was going to become a lawyer. Secondly, my become a judge, sorry. We're about to have our first elections, and I'm feeling uneasy. You see, I feel uneasy quite easily. And I'm saying to myself, Albie, what's going on? And I realize the ANC to which I belong is going to become the government. Will I be Minister of Justice? Mm-hmm. And there are four of us on the Constitutional Committee, and it could be Dalla Omar, and it could be Zola Squia, and it could be Kada Asmal or Albie Sachs. And I thought, no. I haven't spent my life wondering, will the phone ring? It was like robbing me of all my passion and idealism and the grandiosity, if you like, of the endeavor. It's a beautiful, marvelous, amazing endeavor. And now I'm wondering, will the phone ring? So I stepped out of politics, made it very clear I'm not available, and the way it saved me. I believe in politicians. We need politicians. It's easy to kick them. We really need them. We need political parties, but it wasn't for me. It wasn't for me. And I found going on the court, I could carry on the same trajectory, and some of us, we were breakers. We were people who were angry. We wanted to tear down. Some of us wanted to heal. We wanted to heal. We wanted to build. And I felt as the judges, we could build. And our country was going through and still has so much pain. And if we judges don't feel that pain, our people have so much hope and so much eagerness and so much that they want. If we don't feel that as judges, we can't be real judges. We're not in touch, with those deep, profound emotions and expectations that lie at the heart. When I was asked at one stage, after I came out of hospital, blown up by a apartheid bomb in my car, and I'm in Dublin, table of Kada Asmal, the kitchen, and Oliver Tambo, the leader of the ANC, he knew his medicine. He knew my best healing was to ask me to help write a Bill of Rights. Whatever the doctors might say and the physios might say, and that was the best thing. And I remember sitting at a table and saying, if a Bill of Rights doesn't proclaim itself from inside you, you're not getting it right. No books, no texts. And I wrote down a whole range of things and then looked at, and it was all there. And it's that kind of not intuitive, it's because it's tutored. We've been in law for years. We've dealt with it. We've dealt with the cases, the arguments. So we're not raw. It's not just a blind, unformed, unshaped intuition we have. It's an intuition that's been developed over struggles with your colleagues, which can be very exciting and sometimes very bruising, but struggle all the time. And it's that sense of connection. And then that also allows me to mention even the building that we were in. We wanted to decolonize the building. And we would have said, the Canadian Supreme Court is a magnificent building. We don't want it. We don't want it. It represents an era where it was felt necessary to show the majesty of the law. And that's great. It stands out. It's impregnable. It's dependable. All those themes come in. And it's beautiful because the ideas contained in the Constitution are beautiful. But life for our people is hard. People are intimidated by the law. Buildings put them off. They feel small. They walk into a building like this and they want to know, will somebody take me to... and we actually had a competition for our new building, and we chose the site of the old Fort Prison deliberately. We South Africans brag. We brag that we have the only prison in the world where both Gandhi and Mandela were locked up. And no one else can make that claim. And that's where we put our court. And we took bricks from the old awaiting trial block, and the bricks are part of the court chamber. So it's not these beautiful panels, it's bricks. The bricks that we're holding our people oppressed are now the guarantees of justice. It's filled with beautiful artwork. It's got tapestries and sculpture and paintings. They said, Albie, we won't allow you to put Marlene Dumas in the court chamber itself, but you can have the rest of the building. It's very friendly. I doubt that there's another court in the world where people can sit wearing a T-shirt saying HIV positive. But it wasn't seen as intrusive or unfair. It was seen as people claiming justice in a very dignified and quiet way. So the building itself then became a project. I sit here, maybe I would feel uncomfortable when I sat on the court. There's a ribbon of glass through the wall, and you can see people walking by. The architects came up with that idea. We're living in a real world, not a cloistered world. So these are sort of indirect responses to the question that you put to me. But what I can say is that feeling of human dignity, of humanity, in a country where humanity and dignity were denied by the law, by the state, denied in consciousness, that's central to our project. Law without that, if law is just rules, it's not going to work. And on our court, and I'll end with this, I remember at one stage feeling so happy. Here am I sitting with my one arm, and over there is Zakia Koob, who's blind, and over there is Edwin Cameron, who's living openly with HIV, a gay man. And I felt it's right that the court itself should represent the diversity of the nation. And when we took the oath was taken, it's Zulu, it's Xhosa, Setswana, Afrikaans, English, all these different elements of court presence, personality, style of work, contact, are all part and parcel of humanizing our country that had been so dehumanized.
Thank you for that comprehensive response. Stephen, you and I have talked about the U.S. Supreme Court facing potentially 150 cases that's going to have to work its way through the system in one way or the other. Does a constitutional court what advice would you give to the U.S. Supreme Court? Do you have a framework or an approach? I mean, this morning there was another decision from the Supreme Court with respect to Abreu Garcia.
Well, look, the fundamental framework is exactly what Albie just talked about. It is reference to the duty to uphold the Constitution. And that's not a passing phase. It's of course attuned to the surrounding realities, but there's also a quality of almost the eternal that I think has to be in the minds of the judges as they think about their particular role. They're not the political actors. They're not legislators. They're not the enforcers. But they are given I don't want to overstate it, but it's almost a sacred duty to uphold these deep principles that are not just principles of an express constitution, but also I think have emerged, as I say, from practices over generation and generation of the rule of law, the implicit constitution, which we talk about in our country and in countries without historically expressed constitutions in quite the same way that the U.S. has. But they still have that duty, it seems to me. So I would simply encourage the Chief Justice, as he has already done, to stand firm about the independent role of that court and its sacred duty to uphold the principles of the Constitution. Now, of course, there's debate over what exactly that means, but what there can't be debate about is simply ignoring the history and trying to completely revisit in the light of only the contemporary circumstances, it seems to me.
Thank you. I'm going to ask one more question of Albie that you had expressed interest in, Stephen, and then I'll get your response. So, Albie, dignity is a fundamental part of the South African Bill of Rights. It's referred to in 4 sections. You write that the Constitution required the court to adopt an approach that was neither purely libertarian nor simply communitarian, but rather dignitarian. You go on from this to say that universalism must be distinguished from globalization, and that from international principles emerge the quest for human dignity. Would you talk to us about that? Dignity as part of the Constitution, Canada, it's part of the principle of equality.
I think I put that emphasis then. I was writing in New York. I was a scholar in residence, or writing residence, Ford Foundation, on my sabbatical. And some of the debates in the United States Academy between I'm trying to remember the terms now, the extreme libertarians and the communitarians were going through my head. And I agreed with the libertarian critique of the communitarians and the communitarians' critique of the libertarians. And I'm not normally in the middle. I was told when I first visited Canada, why did the Canadian chicken cross the road? The first was to get to the middle. That was the first joke I heard in Canada. But now I found myself in the middle, uncomfortably, but quite joyously, that the dignitarian approach accepted that each one of us is a unique person, individual, entitled to our own personality, and rights have to take account of that and to lead our lives. And I've fought hard to lead my life in my own way. At the same time, we live in families, we live in relationships, we live in neighborhoods, we live in communities, we live in countries, and that's such an important part of our lives. And in Africa, the term Ubuntu is used, that I'm a person because you're a person. I can't separate my humanity from acknowledging your humanity, and I enrich my humanity by acknowledging. I don't fight you off. You're not the enemy. We're not atoms battering against each other. We're people living in these communities. So I found the theme of dignity embodied the strengths of the autonomy, libertarian approach, and the strengths of acknowledging the sociability. And the text is there. It's not just Albie trying to play around with beautiful words. We have to interpret the Bill of Rights to promote human dignity, equality, freedom. Freedom doesn't come first. Freedom on its own without dignity can be freedom for the powerful, the rich, to do what they like, to spoil the world, even to spoil the universe. But you need equality, and dignity is number one. And maybe because it was so much at the heart of the ugliness of colonialism, of slavery before that, of colonization, of disrespectful people, you can't get to equality, you can't get to freedom if you're not tackling the damage that's been wreaked and imposed upon human beings. And it also meant rights for wealthy people, not just poor people, rights for people who happen to love persons of the same gender. Their dignity is assailed. It could be rights for women who had everything in terms of things, cars, husband, lovers, sporting skills and all the rest, and yet treated as a youngster who has to be dealt with great courtesy and respect because she's so frail. That theme of dignity, in a way, reached out to all sectors of society and became very, to my mind, very profoundly imbuing the constitutional project with more than just prevention of abuse. It's giving a texture, a quality to human existence, a self-meaning for people and meaning for people in groups. So I loved that. And when we had to write up on the walls of the court, the architects didn't want Roman lettering. They wanted something personal. So they asked Chief Justice Chaskelson to write some words. He said human dignity, equality, freedom. 11 languages, 11 judges. We each wrote in a different language. Human dignity, equality, freedom. And it was like, I was hoping, by the way, my handwriting would improve because I had a very feeble handwriting. Now I'm writing with my left. Fly, 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 dog, 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 dog. Whole pages of it, and it came out equally feeble. I wanted Mont Blanc pen, and it was equally feeble. But I can say, and I don't think any Canadian judges can say, my words are written in concrete.
Stephen, on this question of dignity as being an important part of the role of a court in its decisions.
Well, I want to just pick up on one very quick phrase that you had, which is that when you're thinking about the Constitution, it's not just about correcting for abuse. I actually think that's profound. And of course, the word itself, Constitution, is about creation. It's about originating. It's about managing society, creating structures, creating institutions, upholding them. And I think that that's where the dignity question can play itself out profoundly, and it's where a court has a particular unique ability to, I think, assess the complexities of a situation, which is very often very hard to do in the political realm, because you're put into a position of either or, having to explain something in the most simple terms. Courts, although one hopes will be able to explain things in a way that people can understand, innately have an ability to think through more complex relationships. And your focus on dignity as relational, I think, is crucial in that respect. So if a court is going to imagine creating, upholding, supporting the institutions that allow society to function, it's through the upholding of relationships and the constituting of dignity.
That leads very nicely to a question that comes from the floor. Both of you spoke about the role that the reaction of the executive branch plays on reinforcing or undermining the legitimacy of the court and the rule of law. But those reactions are largely out of a court's control. Is there something that an apex court can do in or outside of their judgments to encourage fidelity to the rule of law by other branches of government? It's a good question.
Do you want me to start?
Sure, please.
Look, there are things that I think a court can do in its functions that can ensure that it is not perceived to be overreaching, it is not perceived to be a frankly political actor. So I think there are mechanisms of judgment and mechanisms of institutional sensibility that have to play out in apex courts so that they don't generate a kind of antipathy and a sense of illegitimacy. But I want to say a word about sort of crisis situations. I don't know whether any of you followed this, but in the last days of the former Polish government, in the so-called Law and Justice Party, neither of the above. There were systematic attacks on the Polish judiciary, systematic attacks for years. And they got worse and worse and worse. And they were legislative, and they were also just political in the public sphere. And it's really remarkable what happened. The courts and the leadership of the senior courts first tried to use their natural mechanisms that I've just referred to, just by being disciplined, by potentially going to the European court system, although they decided not to at the end of the day. We could go into that. But what actually happened at the end of the day was that they went out on the streets. Now, I'm not advocating this generally as an approach, but there are moments of crisis where the courts have to, I think, stand for the rule of law. Now, it's really important to say the courts were extremely careful that they never connected with the opposition political parties, not at all. But instead, they went out first into schools, into theaters, they went to rock concerts, they had moot courts, they did all sorts of things to help people understand why the rule of law mattered in their communities, as you were talking about. So they did that first, and then there was a very famous moment, I think it was called the March of 1,000 Robes, January 2020, and actually 30,000 lawyers and judges, including people in solidarity from other European countries, went out on the streets simply to defend the rule of law. And amazingly, it worked. The government started to get nervous, and then luckily, in my view, they ultimately lost the next election. But in that moment of crisis, the judges upheld the rule of law in ways that you would never have to imagine, and they were scared. I mean, there are wonderful quotes about how nervous they were in doing this and how they knew, literally, they were skating on thin ice sometimes. That's a quote from a couple of the judges. But I do think what it tells me, and I'll stop here, is there are moments when you may have to be more assertive than judges are used to being. That's the point I will make. And secondly, that being together in solidarity in those moments, not relying on individuals to have to stand up all the time, I think is very, very important. And it'll be interesting to see what happens as things play out south of the border, whether or not that kind of solidarity in the judicial system can express itself clearly. It has failed to do so in the university system, for example, utterly failed in I think, quite shocking ways. But whether the judicial system and the legal system as a whole will be able to express itself in solidarity, I think is a very important question.
Do you want to offer a comment on that, or do you want another question of your own?
Another question.
Okay. So this actually comes from a good friend of yours, or at least her name is mentioned, and it's Justice Rosie Abella. And the writer of this question says that Rosie has expressed concern about the phrase rule of law as omitting critical aspects of liberal democratic orders, for example, freedom of the press. And it's this concern, if I perceive it and interpret this correctly, that a procedural rule of law is not enough, that it's an insufficient foundational building block, and it doesn't have enough in it to prevent the enforcement of laws that are unjust.
Right. Well, I think, in a sense, everything I was saying was towards that rule of law in terms simply of procedure and having some legal justification, inverted commas, for what you're doing, some authoritative body that's in charge of the law of the country, is not only not enough, it actually can be malign. And it makes me think of colleagues of mine, or people I knew who were judges under apartheid. I didn't answer that when you put that question to me earlier. And we loved having decent judges there, even in a very unjust system. There was a famous dispute between Professor Dugard and Professor Wax. Professor Wax saying the judges must resign because they're giving legitimacy to an unjust system, a veneer of fairness. And Dugard, who was actually much more in touch with struggle, we wanted some decent judges there. We wanted some decent judges there because there'd be fewer death sentences. You could expose torture. You could keep open as much as possible. And we were looking to the future, and we wanted to build on that. So, but really everything I'm saying is getting beyond the purely procedural aspect of rule of law, but to fully support what Stephen's saying. Sometimes when that rule of law, that basic thing is under threat, then you don't go into the niceties of laws pretensions and laws not doing that and the other. You get in there and you defend those very, very basic things. And I'm just wondering how shocked American people, ordinary people, will be at where the attack comes from the center. It's on vulnerable groups that are not popular, the abuses of due process, the denials. So to speak about these demonical, diabolical people with tattoos who wreaking havoc, we are defending the rule of law by chucking them out. And will people say, as we said in our court, it's precisely those people who are most violently opposed to what you're doing, called terrorists, called this, called that and the other, where proper rule of law is most needed to distinguish yourselves from the people who are trying to undermine the democratic system. And where it's most needed, and we said so in many judgments, where we had Dr. Death, the guy charged with making biological weapons to destroy the resistance to apartheid, and I argued very strongly it's a constitutional matter, it's a war crimes matter, we should hear it, but hearing it doesn't mean because the accusations are so terrible, he shouldn't get the full support of the rule of law. When we had mercenaries who were going to fly from South Africa to Equatorial Guinea to kill the president there, they were captured in Zimbabwe. The relatives came rushing to the court to uphold the Bill of Rights in favor of the killers who were going for money to kill others. It was very, very perverse, the whole thing. And I remember saying to counsel, you rush into a lion's den and you complain there's a lion there. But the fact is, you rush into a lion's den, even then, even if you brought it on yourself, no death penalty, no torture. And we said our foreign affairs must do everything to save them from that. So I think the real test then of the court is when the groups who are now being denied rule of law, with support of large sections of the community, will the courts then stand up and say, we might be unpopular, but if we want coherence, if we want continuity, if we want the true depth of this notion of fundamental rights, you call it fundamental because it's difficult. Otherwise, it's not fundamental, it's easy. That's the real test. And that's why I felt so proud of our court, that we were always speaking about the disadvantaged, the marginalized. The law must be there. So if the rule of law only protects the wealthy, the powerful, and stops at the front door and spousal abuse is going on, it's the rule of law meeting all procedural elements, but not the substantive one of enabling people to be protected, or in the mines, or in the factories, or people who happen to love somebody of the same thing, or people who have binary personalities and biological aspects.
Perfect. Stephen.
So perhaps surprisingly, I partly agree with Rosie, and she and I have had this conversation quite a few times. For those of you who follow legal theory, this is actually the Hart-Fuller debate, right? This is going right back to whether or not procedural rule of law is strong enough to uphold the sort of integrity of a legal system. And the point I was trying to make, and the reason I partly agree with Rosalie Abella, is that what I said, I think, is that the rule of law is not the answer to every question. but it is a fundamental basis upon which all of these other rights and freedoms can be built, often through political processes and processes of legitimacy in society that don't draw on the rule of law alone, but draw on notions like dignity and freedom and equality, which I would argue are not in and of themselves the rule of law. But why does that procedural element matter? In the Hart-Fuller debate, there was a wonderful moment where Lon Fuller talks about the difference between attacks on people that are with the fists and those that are with the elbows. And the fists are the things that you sort of see all the time. You know that you're being attacked. But if you're sitting on a bench and someone's sort of slowly elbowing you off the bench, you can find yourself in a position where you fall off. And the argument that Fuller's making is that the procedural protections, if they're really deeply rooted in the legal system, make it harder for the authoritarian to use the elbows because there are constraints in the decision-making process. For example, you can't just say, I can do anything if I declare national security as the justification, because there are procedures that you have to go through that tell you can't do that. And if you can't do that, it actually becomes harder to use your elbows. And that's why authoritarians always try to overturn procedural protections, because they do matter. They make it possible for people to make arguments within institutional structures that give them protections. But they don't create all the rights and responsibilities of a constitutional democracy. There are other elements of society, other processes that help to create those rights. And I don't argue that they're not important. I argue that they're grounded in processes, arguments, and processes of institutions that are not just an invocation of the rule of law.
Thank you, thank you. So we have about 12, 13 minutes left, and each of these gentlemen wanted to sum up and talk about something that has been significant to them in the course of their legal and judicial careers. I know my third question here from the audience deals with Indigenous rights and Indigenous resistance movements, their importance, and the importance of land redistribution as part of reconciliation within Canada as a colonial state. And I know that, Albie, in our conversations, you had thought that you might address Indigenous issues. So I'm going to let that question be my lead-in to allow you to speak about what was significant to you in this last part.
Okay, I was criticized for going onto the court because Albie will never dissent. He'll always stick up for the government. Now I'm going to dissent from the question. I can't leave without saying more than a thank you to Canadian judges and the Supreme Court. We started with a blank slate. We couldn't use our precedent in South Africa from apartheid law. The whole foundation was so rotten. Even the good judges, we had to start. And we didn't want to make it appear that it's just our own personal views. And our Constitution enabled us to look at, required us to apply international law and look at foreign law. And the American consulate in Johannesburg provided us with American Supreme Court judgments and Larry Tribe. And the Canadians, I'm not sure there was a race who got there first, gave us the Canadian Supreme Court judgments and Peter Hogg. We got beautiful phrases from Larry Tribe, but much more help from Hogg. And we would start at the back to see the particular issues, and it was so appropriate for the Canadian people in 1982 to repatriate their constitution with a Bill of Rights and have 10 years of jurisprudence for our new court in South Africa. So thank you to the people of Canada, but also thank you to the judges. I actually met former Chief Justice Dixon before I was a judge, asked that rather dumb question, what advice would you give to a new court? And he thought for a moment and he said, you're going to need a lot of judicial statecraft. And it's a theme I haven't often seen attributed to the Canadian Supreme Court. I think we got more from that. We learnt about proportionality, we learnt about what it means to be a Canadian, but it's the way you tell your story, the way you intervene, the emphasis you put. The Quebec secession case, when it was coming up, we thought, how can you possibly deal with that? It's so powerful. The judges found a way. The same-sex marriages issue, it wasn't jumping in there, it wasn't the cultural war, it was simply saying the provinces have a right to deal with this. There's nothing in the law that stops them. It's not saying they must. It was like a step-by-step thing. The Manitoba languages issue, what do you do when suddenly all your legislation is unconstitutional? It's finding ways, even reading in that little technical thing, when it's permissible to read in, to save Parliament having to go through a whole lot of nonsense for very obvious changes that are required. So we got all that, but we also got personal friendships. And we got our equality law from a lonely descent. I was at a conference in Newfoundland, Halifax, and Professor Lynn Smith described then the divisions in the Canadian Supreme Court on equality. And it was something like 3-2-2-2-1. And the one was Claire Leroux de Bay. And we had to start now. Equality is so central to New South Africa. And we got nothing from the US. The suspect classifications and into the minorities, it just wasn't helping us. India had the passion and feeling, but the doctrine wasn't all that clear. And Claire Leroux de Bay hit the nail on the head. Human dignity, not formal classifications, like alike, and this, that, and the other. And it became the foundation to our treatment of human dignity, and it had a very surprising indirect consequence that none of us appreciated at the time. All laws differentiate. Classification, treating people differently, is the very nature of law. That's the whole point of having a law. It's only when the law treats people differently in a way that impacts on their dignity for being who they are, that the equality constitution protection comes in, provided a law then gives serves some rational purpose. That's all that's necessary for differentiating, treating people differently. That was picked up at a time when our government was purporting to appoint the Director of Public Prosecution, somebody who had been proven to be a liar. And normally you don't intervene. And the court, after my day, invented rationality as a test. It's not serving a rational purpose. And rationality is now pleaded all the time in every case. When you're losing anything else, you go for rationality. And all of that actually came from Claire. Claire happened to be a marvelous personal friend. And she didn't ask me to do work for the National Judicial Institute. She commanded me. And I obeyed, and we went to Nepal to sensitize the judges there in gender issues. We went to Sri Lanka to do the same thing. A marvelous friend, a Quebecois person with that energy and spirit that was so special, but also many other wonderful people I met. The former Chief Justice became a friend. We met at the Victoria Falls at a conference, a dramatic place and space. And it's something about that combination of seriousness without heaviness, the openness, especially the Dixon-Wilson court, established a kind of a project, a matrix, that we picked up on and invested it with the South African quality as well. But it's a form of, if you like, international solidarity. It's not Workers of the World Unite, it's Judges of the World Unite. And that's why I'm so thrilled and happy to be here today.
Thank you. Over to you, Stephen.
I had the great honor of chairing something called the Working Group on Enforced or Involuntary Disappearances in the United Nations System. And it was actually when Louise Arbour was the High Commissioner for Human Rights. And that organization is a small group. It's called a special procedure of the UN Human Rights System. And its goal was to try to find what had happened to people who had been disappeared all around the world for political reasons. Emerged initially from what had happened in Latin America, but actually extended all around the world. It turns out there are disappeared people, sadly, in hundreds, or scores, I should say, of countries. And one of the most extraordinary moments for me, and I talk about it in the book, was a trip, interestingly, to Nepal, where you just mentioned, where we were, the working group was invited by the government of Nepal, interestingly, to come and talk about how they would deal with questions of disappearance. And we had the opportunity to go and actually look for people in Nepalese prisons, which was quite dramatic, I can say. You can imagine what the conditions were like. But the moment I want to describe was an extraordinary experience. We were taken by UN officials to meet in a clandestine way with mothers of the disappeared. So a whole group of women whose sons, almost always, there were a few daughters, but mostly sons, had been involved in the Marxist resistance and actually revolutionary attempts within Nepal. And their sons had simply disappeared, often for long periods of time. So I met a particular mother who came up to me, and I was the chair of the working group, and she held my hands. And she just looked into my eyes, and she, through an interpreter, told me that her son had disappeared 10 years ago, and she told me a little bit about the circumstances, and she said she'd tried everything within the political system in Nepal to find him. And then I was standing, and she was about this tall, tiny woman, looking up at me, holding my hands, and she said, "Help me, you are my God." I was gobsmacked. I just thought, oh my heavens, how do you respond to that kind of pain? And what I babbled something about how, of course, we would do everything possible using the mechanisms. I would talk to the government, et cetera, but it was both for me revelatory about what was possible and what was not possible. And the possible was that, and I'll go back to it, the processes and procedures that had been created through this system, which is imperfect, allowed the conversation to take place, allowed me access to discussions with government, allowed for us to visit prisons. And by the way, we actually found disappeared people in prisons, not the son of this woman, but we found disappeared people. On the other hand, could this legal system and process, admittedly an international one, create fairness, create equality, create even justice? No, it couldn't. But it could open up channels that might ultimately lead to those important and crucial societal goods. So it was a moment, a bit of a crisis for me, because I really did realize the limitations of everything that I've worked on for most of my life. But it reaffirmed that you have to stick with it, that there are still means by which the hard questions can be asked and addressed. And so I think, as you've described with the Constitutional Court of South Africa, taking the moment that is given to you in times of great urgency and anxiety, and finding the mechanisms that are at your disposal, wherever you find yourself, to try to reaffirm the importance of the rule of law and of processes and procedures that protect people, I think is the great gift we're given as members of this tremendous group of legally trained people.
Perfect. Thank you so much.